This is Michael Popok, Legal AF. Donald Trump might not be able to keep track of all the arguments he's ever made in various filings with courts, but you know who can? Jack Smith. And Jack Smith, in his most recent filing to the D.C. Court of Appeals, has done two really fantastic things that need to be applauded. One is that he's not only aiming for the audience of the three-judge panel that's deciding at first whether Donald Trump has some sort of immunity from criminal prosecution at the D.C. Court of Appeals level. He's aiming higher. His brief cites frequently cases involving John Roberts, the Chief Justice, Kavanaugh, Alito, and Thomas in order to try to convince them, when and if they get the case, that Donald Trump and no person like Donald Trump should ever be granted presidential immunity from criminal conduct while he was in office, especially when he's being prosecuted when he's left office. So they do two things in the brief. They cite and hit hard case law precedent, including a case of Trump versus Vance, a 2020 case out of New York, which I'll go into in more detail, which was written by John Roberts and joined by actually six others, two in dissent that didn't agree with the proposition in that case, which ultimately said that even a president in office can be subject to some sort of criminal process, in this case subpoenas, and especially if he leaves office. The two in dissent, Alito and Thomas. But Roberts, again, seems to be, for the special counsel's office, the key. Can John Roberts count to 5? Can he get 4 additional votes in order to, if the case comes up to the Supreme Court, find no presidential immunity for criminal conduct while in office, to be able to prosecute a former president once he's left office? Yes or no? Thumbs up or thumbs down? John Roberts has 3 votes, I am sure. This is not going to be that big of a stretch here on this hot take. Kagan, Brown Jackson, and Sotomayor are going to be with John Roberts on this. That's 4. He needs 1 more. Let's make it easy. He's not going to get Alito, and he's not going to get Thomas, not based on their track record of voting and ruling really consistently with Donald Trump and his executive branch. So now that leaves Gorsuch, Kavanaugh, and Amy Coney Barrett in the middle. So the case law that I'm going to go over with you in the brief is focused on Roberts and Kavanaugh, particularly, to try to get Kavanaugh over. Gorsuch could come over too, to the right side, to the bright side, to the light. Amy Coney Barrett could too, although she rarely does. Occasionally, on issues related to guns, she's sort of ruled in the right direction. But on issues of political issues that are at the core of our democracy, I wouldn't want to trust it on Amy Coney Barrett. And now we got Kavanaugh and Gorsuch sort of vying for Thomas's attention and focus to try to get that 5th vote, or maybe even a 6th vote. I'm sure if Roberts makes this ruling, he's not going to be content with like 5-4. He's going to want at least 6-3, if not 7-2. And so that's the vote counting that's going on. In order to assist that, Special Counsel Jack Smith and his team are basically targeting, in a good way, Roberts by citing case law, including the Vance decision. That's one. I'm going to talk about the Vance decision and why it's so important now. And then, as a special comeuppance to hoist Donald Trump on his own petard, the brief also cites to positions Donald Trump's prior lawyers have taken, inconsistent with the position they're taking now in court about presidential immunity and how a president may be shielded from criminal prosecution when he's in office versus when he's not in office. They have taken positions in the past, including in the Vance case, and Jack Smith's team has gone out and found those briefs and has now cited them back to the District Court of Appeals and ultimately to the United States Supreme Court. Let me go over both of those really fantastic stratagems used by Jack Smith. One, through the way the case law is written, the momentum of the case law, the citation of the case law, signal who you're aiming at the court even above the one you're currently at, in this case, the Supreme Court. Important. Calling them out and giving John Roberts the ammunition he needs in order to try to find that 5th vote. And then saying to the appellate courts, the lawyers here for Donald Trump can't be trusted. They're not honest. They're not honest in their advocacy. And these positions they're taking now are completely opposite from the positions that Donald Trump took in his prior filings on issues that were similar, like the Vance case. Let me get right to the brief so you know what I'm talking about. Particularly, they cite, in addition to two major cases that are precedent in this area that you'll hear a lot about, especially on Legal AF, where we break these issues down, is Nixon versus Fitzgerald from 1982, Clinton versus Jones from the 1990s. Those cases are sort of the bedrock, black letter, hornbook law in the area related to president's immunity, in this case, civil immunity. But a more recent case of Trump versus Vance in 2020 came out. And in that case, the Manhattan district attorney at the time, Cy Vance, tried to obtain or had a grand jury issue a subpoena to Mazars, which was the outside accounting firm for Donald Trump, to try to get his tax returns as he was conducting the Stormy Daniels hush money cover-up investigation, which has now led to an indictment after Cy Vance left office. But that went all the way up to the United States Supreme Court as Donald Trump resisted and intervened in the case to try to stop his tax returns, sound familiar, from being produced over to a prosecutor while he was in office. And so there's a whole ruling by John Roberts that's now off-cited, including in this brief, about what type of immunity people should have. And there's also a famous quote in there in which Kavanaugh in the concurrence concedes that there is nothing in the Constitution that establishes presidential immunity, and no man or person is above the law, not even a former president. And that was Kavanaugh in dissent. So I'm going to talk a little bit more about what we find in these briefs. Let me first start with what I liked, when I got a personal giggle about, which is the use of Donald Trump's own words against him. And if you go to, this is for our producers, I'm going to go to page 20 of the brief that was just filed by Jack Smith, and I'm going to read you the points related to the positions taken by Donald Trump in the past. And so here on page 20, you have the lead-in that says at the bottom of page 20, indeed, the executive branch and multiple presidents, including the defendant, Trump, have consistently acknowledged that any criminal immunity ends once a president leaves office. In other words, to answer the question, but he's no longer president, why does he still get immunity? They're using Trump's own words in his own brief filed just as recently as 2020 in the Vance case. Citing from the brief itself, Trump versus Vance, brief of the petitioner, who is Trump, over to page 21, they cite the following quote from that brief of Trump's, emphasizing that the temporary immunity the defendant here sought in that case would, quote, expire when the president leaves office, and therefore would not place the president above the law, answering the question raised by some especially during oral argument, aren't you saying that your version of the president is above the law? They said, no, as soon as he leaves office, he will be at the level of the law. He won't be at above the law. Real talk. 52% of men over 40 experience some form of ED between the ages of 40 and 70. Personally, all of my friends, once they hit 40, started using something to help, whether they admitted it in the locker room or not, because it's always been a taboo topic. Thankfully, HIMSS is changing that by providing affordable access to ED treatment all online. HIMSS is changing men's healthcare by providing access to affordable and discreet sexual health treatments, all from the comfort of your couch. HIMSS provides access to clinically proven generic alternatives to Viagra and Cialis, up to 95% cheaper, with options as low as $2 per dose. The process is simple and 100% online, no uncomfortable doctor's visits. Answer a series of questions on their site, and a medical provider will determine the right treatment option. If prescribed, your medication ships directly to you for free and in discreet packaging. No insurance needed. Pay one low price for your treatments, online visits, ongoing shipments, and provider messaging. HIMSS has hundreds of thousands of trusted subscribers. So if ED is getting you down, it's time to change that. Start your free online visit today at hims.com/legalaf. That's HIMS.com/legalaf for your personalized ED treatment options. HIMS.com/legalaf. Prescriptions require an online consultation with a healthcare provider who will determine if appropriate. Restrictions apply. See website for details and important safety information. Subscription required. Price varies based on product and subscription. That's from Trump's own brief in 2020. Chef's kiss to John Roberts, but that's not the only time they cite that briefing. Later on page 21, they cite from the brief again of Donald Trump about the issue of whether allowing this kind of prosecution of a former president for acts he did while he was president will lead to the opening of a floodgate of lots of criminal investigations, criminal suits. They say, well, that's exactly the opposite position that Donald Trump took just 3 years ago, when in his brief he said, quote, the concern about an avalanche of criminal subpoenas targeting the president is not present in federal court. In other words, federal court has its own protections, and there'll be one, or two or three indictments. They will come through a grand jury process, and subpoenas may be issued through a federal judge and magistrate system. That was the brief of Donald Trump himself. And then you have the citation to the Vance case over and over and over again, particularly the following phrase from the Vance case written by John Roberts: unlike a civil lawsuit, a federal felony prosecution of a former president requires an indictment by a grand jury, which is prohibited from engaging in arbitrary fishing expeditions and initiating investigations out of malice or intent to harass, citing the Vance case. So they cite the Vance case with John Roberts, who was at that point joined by Sotomayor and Kagan. So there were 3 votes right there for all of these propositions that say that the president is not above the law, that especially when he leaves office, he should be subject to criminal prosecution, that the Constitution itself does not provide an express provision of presidential immunity, and that the framers of the Constitution know how to give a federal officer immunity when they want to, and know how to pick up their quill pen and write it into the Constitution, because they did it in places like the speech and debate immunity, which is given to members of Congress for the actions they take within their legislative functions. They can't be sued or prosecuted for those. So in other words, when the founding fathers or framers want to immunize a federal officer, they know how to do it, and they did not do that for the president. Nor did they do that when they had another chance to revisit the issue in the impeachment provision of the Constitution. On the clause about impeachment, it just says that is a process for removal from office or maybe disqualification, but that same person subject to the impeachment process, including in this case the president, is still subject to a criminal process of indictment, trial, and punishment, especially after he leaves office. That is also baked into the Constitution. But again, I defy Donald Trump or anyone to find in the literal text of the Constitution a presidential immunity, especially one as broad as the one that he's promoting. So I think it's great, and I wanted to bring it to everybody's attention, that Jack Smith's team is doing what you're supposed to do, which is go find me case law involving the center of the court, if that even applies any longer, which would be at least votes that we can try to get over to our side: Kavanaugh, Gorsuch, and Roberts, and put them together with the 3 judges on the more Democratic side of the aisle, and make our coalition of 5 to defeat Donald Trump once and for all. That's if it gets to the United States Supreme Court level. We know sitting there are cases like Vance, and John Roberts is just chomping at the bit. Let me make a prediction. If it goes to the Supreme Court level, I'd be shocked if John Roberts doesn't write the ultimate opinion on this, and if he doesn't try to get these 5 votes. I would be shocked if he turned it over to anybody else. If he did, it's in order to get the vote. And then if like Kavanaugh wrote it, that was the trade-off to get the vote, that Kavanaugh would write the decision. So that's that. The other way the Supreme Court can just completely avoid the whole thing and not embroil itself in this kind of political campaign question is just let the D.C. Court of Appeals do its job. It's one of the reasons that they said, yeah, we don't want to take a direct appeal at the U.S. Supreme Court level. Let the D.C. Court of Appeals, which is the intermediary appellate court just above Judge Chutkan, make the ultimate ruling. We think that's going to come here on Legal AF somewhere on the 12th, 13th, or 14th of January. And if they rule as we believe they will, the three-judge panel, which I will predict that the chief judge of that panel, if you will be Judge Pan, I believe. It could be Judge Childs, who was a person who was nominated by Lindsey Graham from South Carolina, but I think it could be Florence Pan. Both of them are Biden appointees. One of the two of them will write the majority opinion, I assure you, and find, I would believe, based on all the precedent, including the Vance versus Trump or Trump versus Vance decision I just outlined, ruling against Donald Trump. If the Supreme Court just wants to say, well, that's it, they can deny the cert petition, the writ of certiorari asking the Supreme Court to take an appeal. Supreme Courts are courts of limited jurisdiction. They decide which cases they're going to take up and which cases they aren't. And if they decide not to take the case up, if there aren't 5 votes to take the case up or to disturb the ruling of the D.C. Court of Appeals, that ruling stands. It could just be per curiam affirmed, or it could be with one sentence, or they could just say, we'll take this appeal on its full briefing, regular course, see everybody in June, which of course is 3 months after the trial of Donald Trump, not what he wants. The underlying trial right now is stayed by the trial judge awaiting the outcome of the D.C. Court of Appeals and or the U.S. Supreme Court. So this thing has to happen fast in order for there to be a March trial date. If the Supreme Court is okay with Donald Trump going to trial in March, they can either hurry up and take an expedited appeal up to them after the D.C. Court of Appeal rules, or they can just hands off and let the D.C. Court of Appeals ruling stand without being disturbed, and or set a briefing schedule that is later in time than the trial, indicating to the world that they want Donald Trump tried before November. I don't know which of those 3 scenarios that the U.S. Supreme Court is going to exercise or adopt, but we'll follow it right here, only on the MeidasTouch Network on Legal AF. We sit at that corner of law, politics, and justice so that you don't have to. We do a show called Legal AF. It's exactly what you think. It's on Wednesdays and Saturdays at 8 p.m. And then the leaders of Legal AF, like me, we bring you hot takes like this one, analyzing things that we curate for you, picked out of the headlines, read in the briefs, and bring it right to you. If you like lawyers who know what they're talking about at the intersection of law, politics, and justice, you'll like hot takes like this one and Legal AF. So give me a thumbs up if you like this analysis, what we're bringing to you. It helps with the ratings, keeps us on the air. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.